Добрый день, уважаемые коллеги. Большое спасибо всем, кто зарегистрировался.
Hello, dear colleagues. Thank you very much for joining, registering for our conference. First International Scientific Practical Conference, The Sphere of Justice. And since we are on a tight schedule related to our speakers' travel plans, also part of our speakers are speaking in their time zones at night time. We are going to keep the welcoming addresses brief and give you the relevant information at the end when agenda isn't pressing. And now, please allow me to give the floor to the floor rector, Vladimir Presnikov, Doctor of Legal Sciences, the person who has helped us a lot with the organization of this conference, Vladimir Sinyukov. Thank you very much, dear colleagues. Very happy to welcome you. We see people filling the audience. The process is ongoing. I hope our communications will recover from the pandemic in a year's time. And the subject of this conference is highly timely today. The institutes of justice are the key institutes of the society that have the sub-governmental sub-state that stand above the state by definition, and the organizers, the name that the organizers chose for this conference, the Sphere of Justice, it's a very good name. This is not a division of responsibility, division of power. Here we have the justice, the law, and its application in practice. And we all see and note that in this sphere, and the whole community is aware of that, justice carries a very important element of going into digital transformation. It is also provided for development of social, economic, political, technological interrelations, and also technological challenges facing the justice system. And this wonderful agenda, so many topics, quite exhaustive of all the trends of development of law. And this agenda is very important for Russia, discussing the doctrine and the practical issues. Justice in Russia and its application of law has a long, controversial, same as internationally controversial history, beginning with 19th century, 1964 legal reform, famous development of the system in the Soviet era, people's courts, Soviet justice, new times, the modern times, 1992 legal reform of the court system, modern administrative reform, administrative justice reform, CC, and also we're in continuous progress, constantly improving latest developments, so constitutional courts, territorial infrastructure division. And we are able to say today that the legal system in Russia is today one of the most effective and modern legal systems in the world. This is witnessed, proven by the fact that we are quite very well accessible to the population. We have very good practice with times of review of legal cases. E-justice is being fast implemented. Independent legal corps are being developed, but it does not mean that the system should not be improved. And the trends noted on the agenda are quite timely for Russian Federation. This is flexibility, this is alternative dispute resolution, ADR, this is arbitrage, and certainly this is new technologies that are now carefully, slowly being implemented into legal process and procedural law. Dear colleagues, once again, we are very happy to welcome all of you. A great number of participants, largest procedural scientific schools of law in the Russian Federation. Very happy to welcome our foreign international guests, and also the creative youth has contributed to this conference. And I'd like to thank you and wish you collaborative work and best of health. Thank you. Dear colleagues, please allow me to give the floor to the Chair of Civil Administrative Law, the mother faculty of this conference, Sergey Mikhailov. Thank you very much, Elena Gennadievna. Dear colleagues, dear students, and guests. Dear friends, the name of our conference doesn't contain any collocations, the problems of theory and practice, prospects and trends. It is called Sphere of Justice. And this name, apart from the legal context, also carries metaphysical, being that the sphere is an ideal shape. And so the job facing the conference today will be to find this ideal form for justice today. This search will not end today. It will continue, and the Faculty of Civil and Administrative Law is this year taking even more responsibility. The faculty is going to take part in the Moscow Legal Forum on the 9th of April with a topic related to optimization of law. And today, in a few weeks, we will come back to the issues of optimization after discussing it today. The next point I would like to note on our conference today, it highlights, in my viewpoint, an ideal means of communication between students and teachers. This is a type of cooperation. This is a form of cooperation. We are an educational institution, and our job is certainly to educate. However, it is no less important to cooperate and work with students, and we were very happy to support the initiative. We are very grateful to the organizing committee, the student organizing committee, and as a teacher, I would like to give you top A's, top marks for organizing this conference, and I hope that our students, our assistants, our faculty staff will earn the same positive distinction. Thank you very much, dear colleagues, dear friends. I'd like to wish everyone a pleasant conference and a fruitful search for ideal forms of justice. Thank you, Sergey. And now the last in our brief welcoming addresses is Fyodor Vakhzhaevich, the director of Alumni of MSAL, Moscow State Legal Academy. Thank you very much, Irene. In the name of alumni of our university, also Academy, as it used to be formally called, and would like to welcome the participants of this conference. The issues on the agenda, their timeliness is certainly noted. We are all observing the development of justice. As practicing lawyers and legal professionals, I'm speaking on behalf of our alumni that we represent. It is also great to see that these issues are also interesting to the student community. As you mentioned correctly, Sergey, the forms are ideal but we'll have to fill it with content. And this is scientific thought. So I'm very happy to welcome, on behalf of the Alumni Association of the Moscow Legal Academy, this conference. We always do our best to support and conduct such similar events. It is especially good to know that this is the first international conference. Let us hope that it makes it to the top 10. All the very best in your work. Thank you very much. And now, dear colleagues, let's move on to the first presentation. Unfortunately, we changed our order. Konstantin Sklovsky, Dr. Legal Sciences, Professor, Private Law School, Higher School of Economics, and a practicing lawyer, is going to tell us about the application of the principle of good faith in the courts. Thank you very much, and thank you for your invitation.
Цивилист, то есть не вполне процессуалист, но тема, которую я предложу...
I'm not quite a procedural expert, but the subjects provided by the conference. It could be called otherwise the challenges facing the Russian justice system related to implementation of the principle of good faith. It is going to be quite problematic to give you a brief description of this content, since it's quite detailed. Formally, the principle of good faith has been introduced into our legal positive law back in 2013 within the reform of the Civil Code, CC here on further. It was introduced in CC reform, and it was further implemented haphazardly in a ad hoc fashion by the Supreme Arbitrage Court using 10th Article CC and abuse of law, and this application has been excessive, and the principle of good faith has been adopted not only in relation to that, but as legal contacts with the European legal community saw expansion, and the Western market played more relevance. International legal community, when discussing with Russian experts contract law or application, were quite surprised that Russian law doesn't contain the principle of good faith. And basically, its application always required additional work. It required specifically prescribing it in the contracts, and when reviewing the disputes in the courts, difficulties had arisen. So it has been reformed. For a number of years it has been more or less passive, and then the application, which sparked a collapse of practice of application, can be related to years 15 through 17. When it was basically came down as an avalanche on top of the courts, and according to for various reasons, whether through experience of application, today any legal case should be accompanied by the statements of good faith, and I will endeavor to give you my vision of the problem applicable to the court's side of things. The principle of good faith is recorded in CC in two short definitions. First, everyone should exercise good faith when exercising duties, responsibilities, and secondly, no one is able to use their illegal behavior, illegal conduct, to benefit. As we see, there is nothing definite, nothing explicit, there is no form in disposition of sanctions, and the principle certainly cannot be indefinite. This is the abstractness of this principle, if one of its main qualities, and this is where it differs from norm. Within their development, the principles may become norm and become accepted, adopted norm. There is a principle of good faith buyer. On the one hand, where this restricted to ownership disputes, the OCC, as we know, it recently tried to see expansion outside this framework. However, the conduct of Constitutional Court when implementing the principle of good faith may be discussed. The courts faced problems in the first years of application of the principle, and the problems were quite acute. I called it a collapse. This can be monitored in any mechanism of application of civil law, speaking of responsibilities, liabilities, even of the filing dates, even of the expiry dates. Since this should be recorded in stone. However, even here we have options where bad faith of the plaintiff can provide basis for the court to review the dates, the periods. And now I would relate this to two key points. First of all, discussing the bad faith is enough to null and void contracts. Today, every second contract, every second transaction is recorded null and void, recognized invalid, based on this principle. And the second point that is also quite important is discussing the illegal behavior from the viewpoint of good faith, and thereby weakening the legal regulation system and the rule of law, because illegal behavior should certainly be followed by sanctions and penalties. So application is not the point here, but the sanction. In terms of contract law, the courts are reacting to the content material. This is what the law states. And relative to this wording, to this content, the court can recognize it legal or rule it illegal and void. The content of transaction of a contract is related to rights and responsibilities. In some cases, the behavior of the parties in contract may also bear relevance. For instance, misleading, deception, violence, and the court can take this into account when allowed by the norms. The novelty of implementing the good faith principle is that the courts begin discussing the good faith of the parties prior to contract, without considering the legality of the actual deal, of the actual transaction. No, it raises no questions, and many a time I have heard advocates of this destructive approach that allows to null and void contracts just based on the behavior of the parties, and they say that principle is a very important point. It's basis, the cornerstone of the law. So how can you rule that contract valued when you discover bad faith. So there are such grandstanding statements, but nothing legal in substance is what I note. And now, speaking of the principle of illegal conduct, illegal liability, I may give you some legal points. And the key is that the principle of good faith can only be used by the courts in specific case law application. In one of the cases, for instance, the director, in conflict with the founders of the company, understanding he is to be fired, had counterfeited the documents of the society. The society provided was in the services business, having good clients, regular key client list, and somebody got that and wrote them that now all the contracts will be changed to another entity, and another entity would be the company that he founded himself. And so the customers had no doubts. Well, if there is a change of a legal entity, no problem. If you have an internal reorganization, it's no problem. Then he left the company, retired and resigned, and began his own business. When the company founder sued him, the court came back with a following formulation. Since he actually did counterfeit the protocol, but we see good faith because he knew he could execute these contracts. Without him, the company couldn't execute it and go bankrupt. He only wanted good for everyone, so it was in good faith. I'm not going to go into the legal argument of the judicial ruling in this case, but in such case, illegal behavior was ruled in good faith and not applied any sanctions. Now coming back to the CC text wording, you have to exercise good faith when exercising law, exercising rights and responsibilities. So good faith, same as bad faith, are attributes of legal behavior. Illegal behavior doesn't bear this attribute, since this is a legal quality. And this is the only way it could be interpreted. If the behavior is illegal, the attribute is not triggered. The next clause of Article 1 states that no one should exercise illegal behavior or bad faith to own benefit. So the law draws a distinction here, but the courts in this and many other cases do not see this line. And this is actually a serious problem, and it's also a legal problem, since we have to understand what can be done with the principle of good faith. Since when I mentioned a huge body of law, legal of lawyers that consider that transactions and contracts can be ruled null and void due to bad faith. That's why today in our law we have an absolute prohibition to a good faith conduct. So their arguments are unbelievable, because prohibition is, as a legal category, is only possible towards a certain category of behavior, and certainly it should have a clear, definite norm of law. Undefined crime cannot be punished since there is no punishment or penalty for a crime that has not been yet undefined. So in this case, bad faith conduct is indefinite, and as well, that's why it cannot be subject of prohibition. However, there are many interpretations, and their proliferation goes to the courts. The doctrine is quite behind, the courts are collapsing, and what can the doctrine provide us here? We may notice the following from the case law. 25th resolution of the Supreme Court stated, as you're aware, the High Court of Arbitrage has been liquidated, reformed by that time. This was one of the arguments adopted by the Supreme Court in the absence of the former. And I have quite a high opinion of the High Arbitrage Court, and I'm sure it could review this practice effectively through case law and also relative opinions. In terms of document content, I'm not able to comment to criticize it. The first article states that any court should exercise the good faith principle, but further on it states that the courts should use the good faith norms, but not the indefinite definition of Article 1. What is even more important is another section of the resolution. When we're speaking of illegal or antisocial contracts, transactions, it is stressed that these transactions are ruled illegal and void according to content, and there is no relation and bearing on the good faith principles. There is a body of opinion saying that it does contradict European law. The principle of good faith is a basis of justice. So the principle is, if the principle is violated, the cornerstones of justice are violated, thereby violating law. The Supreme Court doesn't support this viewpoint. And hence the question, how do we solve this problem if the Supreme Court doesn't support this viewpoint? It has to be done carefully. We have to understand how to transition from the indefinite good faith principle to specific legal practice that cannot use indefinite concepts as to define facts initially first and then follow up by the norms of law that is based on these prescribed norms for the court to later make its arguments. These are the rules of syllogics in court decisions. In this case, the principles do not contain facts. This is how they differ from norms and law. And many courts say that using principles is a question that is left at judicial they use their own logic at times that they often use for assessing proof. Assessing proof is also a point of deeper conviction. The court doesn't have to explain its reasons. It describes circumstances, facts, and then proof it's valid or not, and then considers effect occurred or not. And this is based on many of their body of experience, legal opinions, and so on. And the principles are often thought to be applied in a similar way. However, no, this is wrong. The principles are part of positive law. They're not part of internal convictions. How can this be used in legal disputes? When it began being implemented, a huge amount of work referred to European experience because we didn't have a very well described application. However, this had to be, of course, reworked for the Russian legal system because it is quite different. So that is the reason for the body of works that appeal to the experience of Weimar Republic, 100-century-old experience when German courts, due to economic crisis, were forced to move from strict contract interpreting and also use the good faith principle to rule them void. Andrei Shirvins, as an expert in German law, in an article dedicated to this issue, notes that following Weimar Republic during Nazi Germany period, the German courts has used good faith principle to defer strict traditional German law. As you know, German constitution has not been repealed, but it did not prevent Nazi courts from operating. And that's why this principle may be different and may also bear destructive consequences that I'm personally more concerned rather than the positive effects that we associated with it when implementing it into our CC. And that's why the question is, how can the courts implement the principle? Only in one clear way, through creating case law, precedence, specific cases, which was also typical for German, French, British, other legal systems. In good faith principle. And of course, the courts should note that specific case law will rule the behavior of parties, the conduct of parties in good faith or in bad faith. Let me give you an example, case in point. In a case where sheriff's office, the sheriffs cannot find the assets of a debtor, so the debtor owes a big amount of money, he understands, and if he is paid, then the sheriff has to be involved, the court-martial has to be involved, because his account will be frozen. And he wanted to avoid forfeiture of his money through opening a side bank account for one day in a different bank and withdrawing the money. So he did that to circumvent. Through some time, the plaintiff learned of the fact and presented a suit not only to the debtor but to his debitor, so to both of them jointly based on Article 10, bad faith, joint damages through circumvention of the law and abuse of law. And the court adopts the lawsuit, and then the second appeals court rejects the case because the opening of an account is not illegal. Transferring funds through the account is not illegal as such per se, and that's why the court saw no basis for satisfying the suit. What were the mistakes of the appeal court? First of all, the illegality doesn't excuse the good faith. Illegality doesn't have this inherent principle. Only when legality of behavior we can discuss good faith, as we know from point 125th resolution of the plenum. Also, the appeal court used the words in its own right, and good faith principle is only important based on case law, based on application. Only the conjunction of factors is viewed, and the conjunction of factors, such as hiding the account from the court-martial, immediate transfer of funds. There were extraordinary circumstances without any documentation properly conducted. The court order for the forfeiture of the money and this concerted action provides us a conclusion that this was a bad faith behavior, bad faith conduct. If this is confirmed by the court, this will go into case law and become a precedent for all the courts reviewing similar cases. Now, where should this be done? This should be done in all the courts. But certainly, if the first court's decision will be confirmed by the Supreme Court, this is also okay, but the Supreme Court did not confirm that. It is afraid of creating precedents. When I was in appeals court, I came to a certain conclusion why it is so. I'm not going to dwell on it. I don't have the same opinion of the Supreme Court. Why, after the correct 25th resolution, they're scared of concerned with creating this precedent system? In practice, quite rarely, legal review and appeals, of course, are a definite element of a proper court system. Reviewing specific cases is also important, and it was very important in the activity of the higher arbitrage court. And when the Supreme Court reviews specific cases and leaves them stand, here they may remove the good faith principle.
Окей.
Please let me remind you of the time procedure. In my opinion, therefore, the Supreme Court is afraid of creating precedents because it is not very confident as the third branch of power, because it is forced here to contradict itself, to counterpose itself. The legislative branch, it doesn't want to be the legislative branch. It wants to just follow the law blindly, and whether they like it or not, the courts will have to create these precedents, or this collapse will lead to no proper procedural application of law. Thank you very much. I think I also agree this is one of the key problems of our justice system, this hesitance to delicately name it of the higher courts. If I understand you correctly, what we call bad faith conduct today should be called that also in the process viewpoint, procedural viewpoint. Yes, I have no doubt the principle stands. It goes through the body of law. I do not see any barriers here. The procedural aspects are different, legal here, but I think the case is clear. Thank you very much, Konstantin Ilyich. I would like to also thank you for finding the time to speak. I now would like to give the floor to the second speaker. That was quite heroic. Nicholas Asandon, the representing Chile Deputy Director, Reform Justice, Legal Reform, Papal University, Professor Law, California University, Santiago, Arbitrage Court Justice, and also worked on the reformation of the civil procedural reform, Chile 2014-15. Chile now 6 a.m. He is with us for an hour already. This is a heroic act. It's admirable. You have the floor, Francis. Sorry, Mr. Osanon, you have the floor.
Hello, good morning, everyone. Thank you for the invitation. For me, it's an honor to be this morning with you from the other part of the world, from South America, Chile. So thank you again very much. In this morning, I believe you are seeing there the presentation. Is that right? Could you please confirm?
Да.
Okay.
Yes.
Thank you. Yes. Okay. So this morning, I will offer you the following structure for this presentation. First of all, I'm going to refer to the access to justice on a 2.0 rule of law context. Then I'll go through the Chilean civil procedural reform, its guidelines and its main features. Then I'll go regarding the ADR or alternative dispute resolution innovations regarding the Chilean civil procedural reform. As a conclusion, I will offer some ideas regarding how to address these issues in the current constitutional debate that this year will be taken in Santiago, in Chile, in the whole country. So first of all, regarding the access to justice on a new context of the rule of law, we teach and we study the main sources of international law regarding the rule of law and due process. So we usually start this study with the Universal Declaration of Human Rights, 1948. Then we go through the European Convention on Human Rights, 1950. Then with the International Covenant on Civil and Political Rights of 1966, and with the American Convention of Human Rights that was enacted in 1969. And if you analyze those international law sources, you'll find the core or the basic principles and guarantees regarding the rule of law and the due process. So you'll see the fair and public hearing right, the right to be treated equally before courts and tribunals, the right to have access to an independent and impartial tribunal established by law. And that's three of the main guarantees associated to the rule of law, in the context of the access to justice in particular. Then, as of this century, as of the beginning of this century, there has been a new paradigm regarding and showed through different instruments. So we find the UN Bangalore principles, for instance, for judicial conduct, which added to the previous principles regarding due process and rule of law, it added the principle of integrity in the following terms: the behavior and conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. And this is very interesting. Justice must not merely be done, but must also be seen to be done. Also, the UN Bangalore principles considered the principles of probity, competence, diligence, among other principles. Also, then you'll see that the Council of Europe, in the implementation measures of 2010, it is stated that the access of justice is of fundamental importance to the rule of law. The judiciary should, within the limits of its power, adopt procedures to facilitate and promote such access. Therefore, you can see that it has been deepened in how the international legal community understands the rule of law and the due process, and adding to the commonly known principle of impartiality, independence, these new principles of integrity and the relation of the integrity with the people's faith that the judicial system is serving, also the importance of the access to justice. And also you'll see that it's not only a declaration of principles, but there are several international case law regarding access of justice and the rule of law. And then you will see, for instance, those cases are from the Inter-American Court of Human Rights in different cases that you will see there. And you will see that, for instance, it is stated that a ban of any domestic rule or measure that imposes costs or otherwise hinders the access of individuals to the courts. So also in the second case, the court declares that it has to be a system affordable to the user. The system that a country deploys and offers to its citizens must be affordable. Also, as a third case that I found, or group of cases, that it not only has to be affordable, but it also has to be delivered on a reasonable time. Okay, there are a few cases regarding that. So you will see that there could be a breach of the due process if a legal system of a country affects any of these more developed principles, or more yes. And also, this is a very complex and it is a topic that will for sure will be needed a whole day to talk about it. But it is these principles are related to this complex concept of legitimacy of government structures, and particularly of the judiciary. Only to offer a few reflections on this, or considerations on this. According to Cruz Prados, the concept of legitimacy of government structures is related to the legitimacy of power. And this concept goes beyond the formal and legal procedures. And the core issue here is the connection of the power that the legal structure has to deploy with the community and with the identity of the people, with its values, particularities, etc. And you will see that similar approximation on Robert P. George. So there you will see that you can address with this new perspective of improving access to justice, of improving a reasonable time, of improving all of these guarantees of what some lectures call the 2.0 rule of process. You will see also that you can address this complex issue of the legitimacy of government structures, and particularly in this morning of the judiciary. More than, of course, more than of the democratic or formal or legal legitimacy. This is some legitimacy that goes beyond and as a complement to the formal legitimacy. Okay, so that's now you're seeing, for instance, what we are measuring some international instruments. So you will see that the annual report of the OECD named the government at a glance, it considers and it measures this kind of topics, of guarantees to its countries. For instance, in Chile, my country, has a lot. Still, it has a lot to improve regarding the open data and regarding the serving citizens. Then you will see, for instance, the judicial system in the bottom part on the left. You'll see that we are the satisfaction and confidence across public services regarding the judicial system. We are, in my country, we are 24%, and on the average from the OECD, it's 56%. Okay, so this is something that international instruments are measuring, and so it's something that, from the legal perspective, we need to address. Okay, and in addition to this, we find in my country, in Chile, some surveys and polls regarding the civil conflict observation that stated that, for instance, 3 out of 4 households recognize that they have had some problem with a neighborhood or a problem of the neighborhood conflict. Then you will see that a little lower than the half of the population declared that they have had some type of legal need in the last year, and 63% of them declared that it had not been solved yet. Also, almost the half of the population of Chile declared that they don't know where to seek legal advice or assistance in a problem with tenants. Okay, so that's all of what we have revised are the grounds of what we are trying to develop in Chile with the legal community and with the Ministry of Justice regarding how to improve our current civil procedural system. So now you will see the main features of the civil procedural reform that it's in analysis before the Chilean Congress, and in opposition how the system, our current system, deploys. So our civil procedural system, our civil litigation system, the core code is a code enacted on 1902. So it was drafted by the late of the 19th century. Okay, by the late of 19th century, it was drafted, the civil procedural code that now in the year 2021 we use to litigate. Okay, so to put that on perspective, there has been some important reforms, but not structural reforms. For instance, a very important reform was held in 5 years ago, which added electronic litigation. That is very interesting, but it is still, it is an electronic litigation, but on a really old-fashioned civil system, civil procedural system. So our system now has no hearings before courts, mainly written litigation. There are a few exceptions of hearings, and we are trying to move towards procedural structures within public hearings. Our current system is very formal and with written proceedings, and now we will move towards new principles such as mediation before the judge. In Chile, it's not, if you litigate on civil courts, it's not common to see the judge. You can litigate the whole case and you have never seen the judge. But with the new civil procedural reform, we project that there will be, the reform stated that it must be in mediation or real presence before the judge, and the judge must connect in presence with the parties and with the proof or evidence. It gives more ex officio procedural impulse and good faith litigation, among other principles. Also, now the assessment of the civil evidence that you see, that you offer in a case, it is stated by law. So the law states how the judge must assess the evidence. Okay, so for instance, the law states that if you offer two witnesses which are contest in the main or who concord in the core of its declaration, then the judge must give proof to that fact. Okay, and now with this reform, the reform stated the sound judgment criterion for evidence assessment. Also now you have limitations regarding the proof. With the civil procedural reform, you will now have such a limitation. And regarding specifically to this, to one of the main issues of this morning, is that it has no ADR, no alternative dispute resolution regulation, and the civil procedural reform has a strong mediation and conciliation regulation. Okay, so those are the main contrasts from a procedural perspective regarding our system now and the projected system of the civil procedural reform. That's from the procedural perspective, and now you'll see some innovations from the organizational perspective. So this reform incorporates new judicial services, a new public attention, a new civil execution units, and a new notification units. And it offers mediation as a new service that the judicial power and some private centers has to offer. Okay, it also it contains new small claims procedures. In Chile now we don't have a small case system, or we don't have a system to treat the civil small claims, and with this reform we expect to have new small claims procedures. Also, this from the organizational perspective, this reform contains territorial deployment with the creation of new judicial units or new branches of courts that will benefit a large percentage of the population. And now moving towards the civil mediation main features, you will see as a background in Chile, particularly regarding the mediation, that we don't have a lot of experience on civil mediation in Chile, but we have very strong mediation on family and labor, very strong experience, regarding family and labor mediation as of 2005. Then you will see some projects that those are the logos of some projects in my country, but to sum it up, we don't have a strong experience on civil litigation. In Chile, we have of civil mediation. In Chile, we have one large center called the Center of the Santiago Chamber of Commerce, which conduct commercial mediation, but beyond that center, regarding civil and commercial mediation, we don't have that experience if we compare to our very large experience on family and labor mediation. But as a background, we analyze experience all around Latin America, and we find that all of the countries, our neighbors, have civil mediation law and they have deployed a civil mediation system. and they have adopted the multi-door system that was created in the US mainly. And there are some notable cases of Colombia, Brazil, Uruguay, and Argentina regarding these ADR initiatives. Also, we studied the experience of the European Union, and then we'll see also that all the countries have civil mediation and law system. We analyzed the directive from the European Community on civil and commercial mediation. There are several guidelines and recommendations regarding mediation. We have also the UN Citral Model Law Mediation, and also the Singapore Convention regarding international mediation. And this is interesting because Chile is signatory to the Singapore Convention regarding international mediation, but we don't have a strong domestic mediation regulation. But anyway, and this is a good sign, Chile executed, and it's a signatory to the Singapore Convention regarding international mediation. And it is also very interesting, the European Handbook for Mediation Lawmaking from the European Commission of Efficiency of Justice, which has a very interesting study regarding how different countries across Europe have deployed a mediation system. And now, going through some key elements of what we project as the new Chilean mediation system. It contains a mandatory mediation in some civil cases. So it is stated that before entering into a court, the party must, not for all cases, but from some large cases, the party must submit a mandatory mediation. Then, from the organizational perspective, it is stated a dual provision of the mediation, both by the judicial system and by private mediation centers as well. Also, it regulates the procedural effects of the mediation. For instance, it is stated that the suspension of the statute of limitations applicable to judicial actions and the homologation of the mediation agreement as a court judgment. Nowadays, when you have a civil or commercial mediation in Chile, it's kind of a negotiation only. It doesn't have more regulation than a normal negotiation before two parties. You only have a regulation regarding the transaction, okay, but you don't, the contract of transaction, but you don't have a regulation regarding the procedural and the outcome of the mediation. And it contains a regulation of the conduct of the mediators, and also of the principles and of the proceedings of the mediations. Okay, those are some key elements of the projected act that will take place in Chile regarding the mediation. And for instance, as a conclusions, this topic is related or this topic is now related to a current debate that will be held in Chile regarding the constitution, because from a process that began last year. In this year, Chile will initiate a process to draft a new political constitution. So 1.5 years ago, Chile approved a reform, the Congress approved a reform to the current constitution to adopt a new way to draft a new political constitution. And within this context, the ADR deployment is, as we saw recently, is strongly related to the access of justice of the users and therefore to the principle of the rule of law and to the Bangalore principle on judicial conduct. And assuring access of justice is a way to properly address the legitimacy question affecting governments and judicial power. And such principles will enrich the debate and probably will be stated as a constitutional norm directly or indirectly. And I think that's my presentation. Now you will see something that we do in the university. That as the presenter said, I'm the deputy director of the procedural reforms program of the Catholic University. So then you can find some information of what we are doing in Santiago. Thank you.
Спасибо большое, господин Асандон.
Thank you very much. Thank you very much, Mr. Asandon. I'm sure that we will be frequently in touch and exchanging opinions on various issues. And I have a question. When you said Chile is planning a multi-structured ADR system, do you think this multi-layered system should consist of autonomous, independent subjects not controlled by the courts? Or should the system be, in one way or another, be controlled by the courts through, for example, case precedent law of other bodies?
Thank you. Yeah, that's a very interesting topic. So if I got it right, you're referring to the relation before the ADR system and the court system, and whether the mediator or the court or the ADR system will be affected by the court decisions. Am I right?
Совершенно верно.
Absolutely correct.
Okay, great. Yes, that's a very interesting topic. It's a very pertinent question, and I believe that because in Chile we have some experience regarding family and labor mediation, and you see there that there's no interference between family law, labor law, and the mediations and the mediators. And also you will see that as a ground for the mediation is the principle of voluntariness. Okay, so parties are free to agree or to not agree, to settle or to not settle, and that freedom or voluntariness parties will not be affected if the mediation is allocated within the judicial power or outside, because in the first case, the conduction of the mediation will not be done by the judge, neither by a court official, but by a separate grant within the judicial structure, but not by the judge itself. So I think that's not a risk. Of course, as an argument, a party could use some legal case regarding the case, but that's more of a negotiation argument between the parties that they will use regarding the legal case, but it's not something that the mediator will use against one or the other party. Thank you.
Спасибо большое. Я думаю, что сейчас будет самым человечным это отпустить вас спать. Вы и так сделали что-то фантастическое, связавшись с нами столь рано. Но хочу вам сказать, что будет еще одна ссылка сегодня же. И с 3 часов дня мы все-таки попытаемся еще дать возможность посмотреть культурную программу, а именно оперу, которая будет даваться московским, одним из самых известных московских театров, в записи специально для нашей конференции. Об этом чуть позже. Спасибо большое, Фриас Николас Асандон. А в настоящий момент я представляю слово нашему любимому Владимиру Владимировичу Юркову, доктору юридических наук, профессору кафедры гражданского процесса Уральской государственной юридической университета и просто в России одному из самых известных ученых по процессу. Его тема «Эволюция понимания пределов правосудия в постсоветский период. Уроки и перспективы». Прошу вас, Владимир Владимирович.
Добрый день, уважаемые коллеги. Прежде всего, большое спасибо за приглашение здесь принять участие, потому что побывать на кафедре гражданского процесса, где работали такие действительно выдающиеся специалисты, как профессор Гурвич, профессор Шакарян, вот, к сожалению, да, безвременно ушедший из жизни профессор Боннер Александр Тимофеевич, это всегда большая честь и большая радость для меня. Вот. Ну и здесь наша школа традиционно мы дружим тесно. И мне очень тоже нравится у вас то, что вы взяли вот здесь не только национальный, но и сравнительно правовой аспект. Потому что даже вот, если взять маленький комментарий, вот то, о чем выступал профессор Скловский, вообще у нас еще в 2008 году была защита.
If we go back to Professor Sklovsky's comments, back in 2018, we had looked at a PhD dissertation by Vadim Balonin on abuse of law and good faith. He collected a large body of material. He studied the German system. I made a brief presentation, and I'd like to discuss the limits and limitations of justice. I'm sorry for choosing the subjects for the conference. I have selected the most significant works in the Russian doctrine.
Как мы пришли к принципу от отрицания судебной защиты как всеобщей к абсолютизации. Он как раз показал, тем более он был и живой свидетель, и участник этих событий. Очень интересная работа.
It was very interesting second work, Ibrahim Shahate, Legal Reform Theory Practice. He was a deputy director, World Bank, and he was responsible for financing legal programs. World Bank finances not only economic, but world reforms focused on economy. And the key idea of the book was to develop private property mechanisms. We have tried to also analyze the book, finish books of analyzing quality in procedural law. He had received the golden scales of the Council of Europe, translated to many languages. One of my PhD students translated it to Russian, and the Finns have published it. Another good work, translated at the faculty. Our French colleagues here have analyzed doing business reports, which bear relevance not only on economics, but also on law and procedural law. This was my PhD student Alexei Gradov's translation. These were other guys that studied overseas, so it's a very quality translation. Alexei Kurechkin also wrote about this, and also Irina Stritsova's work was very good. This book is quite important. I have once again reread it before coming to the conference, and the author was very correct about asking about limitations of justice related to ADR mechanisms. This is also an issue of scientific process, and what can be privatized is a difficult term. Another functions related to jurisdictions. And within the social public context, the limitations of justice are discussed, and I agree here with the author, saying that justice includes the whole infrastructure, such institutions as the legal community, the lawyer, defenders, public defenders, and notaries. It will not provide full effect if we do not approach this problem comprehensively. We have to address all the parts of this structure. A lot depends on the model. There are two, liberal or social. Liberal, with government providing services, and social, when the state aiming for conflict resolution and social peace. This is an Austrian concept. Minister of Justice Franz Klein, first CC, Austria, 19th century, based on Saxon law, and hence the balance of public and private. Also, the demand for access is important. Next slide is also important. Since we wanted to discuss evolution, in a Soviet period, we did not have a justice system in its full understanding. It was seen more of a law enforcement system with strictly limited competences and authority. Only 3 categories of cases in 1956 were reviewed. All of the rest were outside the scope. Then, following Constitution of 1977, a debate enveloped Article 58 about appealing the actions of officials to courts. And the famous Mikhail Stragovich recently passed away. Approach, he was quite famous, and Soviet professor Oleg Pan. They wrote that we should have full and unrestricted right to appeals. Also, at our faculty, my teachers consider that there should be some extrajudicial conflict resolution mechanism, not to take everything to the courts, provide the opportunity for conflict to be resolved otherwise. This was 1970. This was USSR legislation 1987. Following that, sorry. Technical difficulties.
Дальше, значит, у нас наступила эпоха, если так выразиться, судебного или правового романтизма. Это действительно было так. Многие не верят, но тот, кто жил в эту эпоху, мы помним, тогда казалось, что принятием пары десятков законов мы изменим нашу жизнь, и наступит жизнь. Тогда был популярный сериал «Как в Санта-Барбаре». Вот. Но тогда что оказалось на те процессы? Тогда появились новые доминанты существенные. Это, конечно, изменение понимания правосудия и отражение концепции разделения властей. То есть стало пониматься особое место судебной власти и конечно, стала реализовываться концепция... Да-да, ага, да, отлично, то самое. Вот, и, значит, такой важной также доминантой стала концепция прав человека, которая понимала среди всего также прочего и в том числе право на обращение в суд. И в 90-м году, когда 12 июня была принята Декларация о государственном суверенитете, там право на обращение в суд было зафиксировано как абсолютное право. С этого момента мы ведем отчет о том, что право на судебную защиту стало абсолютизироваться.
Since that time, 1991, we have this concept of legal reform, and I agree with the assessment of Elena, social determinism. She said that justice is a service. She said it's a service provided by the state to the community. So, there was a liberal justice system view reflected here. However, the legal system went down a different track. Social justice. Removing these limitations led to a collapse, since it became impossible when preserving the former size of the legal system and a single legal model. If you recall, the CC USSR of 1964, it became impossible to process the increasing caseload. For this reason, it became an important stimuli, since crisis also provides impetus for development. First, we saw a judicial order in 1995. People's Deputies idea was repealed. Arbitrage courts emerged. Now everyone is saying that court fees should be raised, but not everyone remembers that at the end of 1994, by Yeltsin's presidential decree, they were reduced. It was 15 and 10% respectively was the reduction, and I recall the book report published in 95, where we discovered to our surprise that the number of arbitrage court cases fell by a third year on year. One of the reasons was certainly inflation, God knows what was going on financially, but to give away 10% of the dispute to the court, or 15% total with no unclear result, is certainly doubtable. And this provided statistics we see today. The executive branch has been reformed, notaries were reformed, and arbitrage courts were also reformed. If we look at the CC 95, 92, these were great acts of codification containing very progressive norms. So the legislator here understood and went towards differentiation away from the single-track system. So the key lessons of the 90s are that court protections should not be absolute. They should be switched on only when other means of conflict resolution are impossible. Because certainly we should save what Professor Alexeyev has figuratively called legal energy, because the costs on reviewing the simplest of cases in legal procedure do not correspond to the exit result. And another important point is that our legal system cannot develop without constantly upgrading its infrastructure. So the issue here
судебной и несудебной процедуры. Какое производство лучше для той либо иной категории дел. Ну и всегда неплохо медленное и дорогое правосудие. На самом деле,
And of course, it's a question whether slow justice is bad. Going by international experience, in many countries it is quite long and expensive.
Иногда мы занимаемся конституционной практикой. Помню, в конце 2014 года меня попросили написать несколько заключений по одному делу для германского суда. Там речь шла о том, что применимо было российское процессуальное право.
I remember a German case law
Арбитражная оговорка была
when
российским
arbitrage was subject to Russian law.
Мы
That was a
обменивались
serious point.
сведениями. Это надоело суду. Тогда он вместо частных экспертов назначил государственного.
And these border courts, and for 1.5 years they provided their own reports, and then it was our turn, and it was a subject of appeal. And the first appeal court reviewed the case in 2014, and the subsequent hearings took place only in August 19. So it took 5 years just to get to an appeal stage regarding the competency of the German court, the authority of German court to hear the case. So when we criticize the legal system, we should look at international law as well. So it's a question. And now Mr. Shakhatov correctly wrote in his book that investments are direct and indirect. Direct investments happen when we finance the legal system, infrastructure, buildings, salaries of the judges, staff. But he provides another vector to take place is restructuring the legal system. Not the classic procedure, but simplified procedure, increasing the role of arbitrage courts, simplifying executive and procedural law. I think we went down the track of simplification of legal procedures, excluding procedural communication between the court and the parties. But of course, the will to split the burden with extrajudicial systems are not great. If we look at numbers of cases going through courts, private arbitrage court centers in Russia, the numbers are not huge. Same goes for ADR procedures. One of the colleagues in my faculty is a retired judge, and he was on a list of court mediators. And I asked him, how many did you have in 2020? And he said, not a single case in Sverdlovsk region. Yes, the centers, mediation centers have their work, but he is a court mediator that was on the list got on a list due to the reform of the Supreme Court. He said there are two of us in the section on civil cases. We had not a single claim. Our regional court doesn't record a single case. Not sure of Moscow numbers. So that's the statistics. And since my second job is notary, I always say you can share with the notaries. Why do you need court orders when this could be given to executive, given over to notaries? I'd like you to also note what can be privatized. When the notaries moved to a new legal basis, private notaries began being viewed as completely private. But taking the French concept, they have the concept, a job called officier public. These are public officials. that receive state authority, work under government authority as part of the state, although it's a private, the private element is only the financing and setup of their organization, also controlling bodies such as notary. But I'm not sure whether this was privatization. I think it was a change of legal entity form. In French, it's legal public officials that the government lends the authority, providing certain rights. And speaking of the non-public system, will this be for enforcement? Will this be privatization? I think this is quite complex. The international experience suggests it's not privatization, but a very strict system, very well organized, working under the auspices of the Ministry of Justice and on Chamber of Court Marshals. And trying to look into the future. When we look for this balance, there are certain advantages. When we heard the report from the colleague from Chile, we understand the situation isn't so bad. We have legislated time periods. We have no barriers for appeals or cassation. For instance, in the UK, according to our law, it's quite clear you need to get permission to appeal from the judge who brought forward the decision. In many countries, it's a 10k euro barrier to arbitrage. Otherwise, Finnish courts will not be burdened. And I have been an expert in English common law trials, in English arbitrage. And if the cases start in April, they end in late autumn. As long as they like, they take as long as they like. So when we speak of the periods and dates, our system has many positive factors. Although we see that we are now seeing barriers for appeals, on a number of cases appeals have been removed, a number of cases are simplified, for court orders very limited scope of appeal. Has to do with arbitrage, I would like to note also important element of the justice system becoming more similar, more court-like. It is losing the flexibility, the agility it used to have. The European Human Rights Committee introduces minimum standards of human rights protections, not just for government courts, but also arbitrage. And the executive branch, the enforcement, is sometimes procedurally more complex than preceding stages of legal proceedings. I'm part of the Human Rights Committee Council, and we say this is wrong. Why are your procedures for enforcement are more complex than the court orders you're acting on? And I think they're beginning to work on this and understand the importance of this problem. And certainly we need to be client-oriented. Elena, you were very correct in criticizing this concept, but the Finns meant client-orientedness, mean very well-developed procedures, good communication systems, document filing systems. Even if you go to the High Court of England or Wales, and in the break, people in a high court. High court has very modern facilities, and every group of lawyers can rent their premises, take breaks, sit in their own chambers, look at their documents without hiding behind the columns of lower courts. So, these are just some examples. And dear colleagues, now I'd like to give you the last report, European Commission Efficiency Justice 2020. Very positive, this judicial analyst was very positive in assessing the Russian justice legal system, one of the least costly of the 47 European court systems. And now, in conclusion, I would like to go to the limitations of justice when comparing when comparing civil and administrative law. Now we have a report called Doing Business, and this report attempted to number all the economies and legal systems, number of criteria, and one of the criteria is the speed of contracts, entering contracts, the speed of conflict resolution, the speed of getting permits to new construction, and so on. And because many of us are French speakers at our faculty, we are very close with the friends of French legal culture, of Henri Capetan, and it's a community of lawyers and doctors. They prepared their own report. We translated it to Russian. It's not big. It's about 150 pages. The French were very surprised to end up somewhere between Rwanda and Burundi in Doing Business report, despite France being one of the easiest countries when purchasing property. Doing business is probably a bit harder due to more socialism than we used to have in the USSR. And I think this report was published as a book, and then 2012 presidential decrees, Russian Federation included the idea to return to place 20 from being 120 in the ratings. And this impacted the changes to our procedural. We use standards of proof, group indirect suits, subsidiary liability, special administrative areas, international company law. So we have some positive and negative impact because business reports have a very single purpose, just to market the systems of common law. Because the best world economy is American, this is their position. Those that accept this view and American law standards will reach best development results. Actually, the impact differs. As you know, Kazakhstan has International Arbitrage Center, Astana, 9 British judges, but I think the approach stimulates us to be client-focused, to look and view towards new means of legal protections, arbitrage, non-budgetary enforcement execution, but not against notariate. I like the position of our German colleagues, very analytical. And in November 19, Jakarta, Indonesia, a Congress opened by Indonesian President also noted Doing Business report that Indonesia has to rise in this report. And I really enjoyed the address by a German colleague who said that Germany is number 4 in GDP in the world, but 74 in doing business. And he said, where does it go wrong? How do we take this information? This is why I wonder if this can be taken as a guideline. But if we move up in the ratings according to some unclear criteria, I don't think it will lead to Santa Barbara. Quoting, unquoting. And so this is our constant search for the limitations of justice. Russian choice today is de-ritualization, simplification of legal procedures, procedural law. Other systems of legal protections do not enjoy significant support. And of course, we need to consider that the world has now competing systems based on economics, and this struggle will exacerbate this huge international legal industry in London, for instance, focused on Russia and CIS countries. Very customer focused. It's a huge business, so we have to also market our system. That's all for me. And now we can conclude with a phrase, with a quotation from Hegel. Now, speaker quoting Hegel. In private law, the so-called perfection is constant advancement, and this is fully applicable to law. So I think new problems will also arise, but we need to continue searching. Thank you very much. Your assessment was very important. I would like to ask you, in your report, you said that the demand on cases will serve as a marker on where to file. Do you feel that the more demanded, more popular cases should go to the courts or least demanded cases? Well, I think we have different criteria and also public-private interest, the degree of interest, the arguments on divorce, family law, labor can stay under government auspices. Bankruptcy law also remain fully under government control, although some procedures do see simplification. So this is going to be a lengthy process with letting go of some checks and balances, creating such publicly controlled institutions. Thank you for your presentation and your visitation. We always look forward to seeing you. Dear colleagues, and there was a speaker from Singapore, Xavier Francis, the partner, Rajan Tan, the president of South Asia Pacific Legal Association, senior counselor with the Supreme Court of Singapore and also England and Wales, the person who has opportunity to review legal problems as an arbiter, in arbitrage, as a government expert, as a justice, a unique expert as a lawyer, a unique expert. We're very happy to have invited. His report will review dispute resolution prospects and risks. Xavier Francis, you have the floor.
State court litigation with international arbitration and I'm going to be talking about key developments across the globe. The first thing I want to say is that today, international arbitration is the #1 preferred dispute resolution method for cross-border disputes. In a 2018 study carried out by the University of London, the Queen Mary study, what they found was that 97% of the lawyers and in-house counsel who were surveyed chose international arbitration as the dispute resolution method of choice. So international arbitration is really king of the hill today. And today we have 167 countries that have signed the 1958 New York Convention. The latest country was Malawi on the 4th of this month, 4th of March. Now, why has arbitration become the most popular method for dispute resolution? It has become so over the years, over the last 2 decades, because court litigation was previously very costly. Court litigation previously was very slow. And of course, because of the New York Convention, you can enforce arbitration awards across the world. The fourth reason is because, as you know, arbitration is a confidential process. It's a private hearing. And finally, there is no appeal from arbitration awards. So the arbitration award is final, and there is no appeal. Now, today, we are facing something quite unique in that users all across the world are unhappy with arbitration for many reasons, right? And arbitration today is being criticized as not doing well in the areas that in fact made it popular. So the first area of complaint in the latest study, the Queen Mary study of 2018, is that arbitration is now very expensive, right? And today, ironically, state court litigation can be cheaper than arbitration in most cases. And what has happened is that one complaint is that the arbitration process has borrowed too many techniques from court litigation. So for instance, there is extensive disclosure requirements. There are lengthy submissions in arbitrations, and there are extensive cross-examination of witnesses. Something that, you know, especially civil law lawyers and Russian lawyers would find very strange. So arbitration has become costly because of that, right? And there is also a complaint that arbitrators are not being strict with procedural rigor and discipline. And for instance, in 2016, as an example, the ICC introduced a mechanism by which arbitrator fees would be reduced by 5 to 20% or more if the award is delayed by more than 3 months, right? If the award is not issued within 3 months of the last step in the hearing, either the hearing or the last filing of a submission. So that's the first complaint. Arbitration is expensive. The second complaint is that arbitration has become slow because of the same sort of reasons, lack of arbitrator discipline in the process. And one other problem that we face in arbitrations today is that there is a limited pool of acceptable arbitrators. And so these arbitrators are very often appointed in many cases, and they're overworked. Another complaint is that arbitrators are not sufficiently proactive. Example, in identifying preliminary issues. And also that arbitrators are very slow in issuing awards. So second complaint, arbitration is taking too long. Now, the third thing I want to point out is that even though arbitral awards have a wide degree of enforceability, but in real life, there are issues in many countries with the proper enforcement of arbitral awards. And so you can't take it for granted that arbitral awards are enforced widely. And on top of that, you have to remember, because of the 2015 and the 2019 Hague Conventions on the recognition and enforcement of foreign judgments, court judgments are slowly but surely gaining traction in enforceability across many countries. The next point to note is that arbitration is very popular because of the confidentiality of the proceedings. It's private. But again, one needs to realize that confidentiality is not automatic in arbitration. In fact, many arbitral rules and seat legislation do not uniformly provide for confidentiality. Now, but confidentiality has a flip side to it, right? Because arbitral awards are confidential, unlike court decisions which are public, you do not get a consistent and coherent development of legal principles in arbitration, right? And that is a huge criticism that has been made of arbitration, that because arbitrations are ad hoc, the awards are ad hoc, and the awards are private and confidential, you do not have legal development of principles as you do in court litigation and judgments. Now, the final advantage of arbitration, which is much talked about, is the fact that the award is final. You can't appeal it except for very exceptional grounds, right? Like bias, breach of natural justice, and so on. But now, this finality of the award has become a weakness for many users because they are finding that arbitrator performance is not up to par, and therefore the award that is final has errors, and there is no mechanism to properly correct or rectify the errors, right? So I come now to my next point, which is the second largest complaint of arbitration users, which is, they say, the second worst characteristic today of international arbitration is questionable arbitrator involvement and weak arbitrator performance. So one big criticism that has been made is that arbitrators are biased in favor of the appointing party, right? So there are questions over the appointment system, and there is uncertainty being expressed over the ethical conduct or the ethical code of arbitrators. And this is compounded by the fact that there is no clear supervisory or transparent supervisory role, oversight over arbitrators. You know, unlike in a court system, a judge would be overseen by a panel of judges or a higher appellate court or the chief justice, but that's not the case for private ad hoc arbitration. And another complaint is that, you know, there's no one to supervise arbitrator performance. So there are complaints that arbitrators are not prepared for arbitration hearings, they're not producing quality awards, and nothing can be done to correct it. Now, the next point I want to talk about is the fact that, so as time goes on, two things have happened, right? Some dispute resolution users are in fact finding that municipal court or state court litigation is becoming attractive in some parts of the world, you know, where the courts are efficient, transparent, and there are quality judges. But the larger sort of development is the emergence of international commercial courts across the globe. And you'd be familiar with that, right? So from Europe, London, of course, is a commercial court that has been there since for a long time. But across Europe, in the Middle East, in Asia, you know, one example is the Singapore International Commercial Court. So the emergence of these strong international commercial courts are actually becoming a very strong competitor to international arbitration for the resolution of cross-border disputes. And many people, you know, take the view that if one were to look at, say, dispute resolution before a court like the Singapore International Commercial Court or the London Commercial Court, they say that, there are lower court fees to be incurred. The courts are fairly quick. There is a quality of judges. There is a transparent quality of adjudication because the judgments are made public. There are open hearings, so there's transparency as well. And because there are judgments that are made public, there is development of the law. And interestingly enough, I want to point out that one of the reasons why international commercial courts have become very popular is that they have borrowed procedures from international arbitration, such as chess club, where there's a limit to the amount of time you can cross-examine a witness. And another way to limit cross-examination of expert witnesses, for example, is witness conferencing or hot tubbing, which is now almost customary in, say, these international commercial courts like London or Singapore. And document disclosure is limited. It's not the wide-ranging disclosure that you get, say, in the United States. And on top of that, the final point I want to make here in terms of the advantages of the international commercial courts is that unlike arbitration, an international commercial court can bring other related parties who are not signatories to the specific contract into the case, whereas that's not possible by and large in international arbitration. And in international commercial courts like Singapore, for instance, you can decide whether you want an appeal avenue or you want a limited appeal avenue or no appeals from your first instance judgments, right? So you have that flexibility, right? So as a result, I think the net result is that certain international commercial courts like London and Singapore are actually becoming very popular. But at the same time, currently international arbitration is still popular, but obviously the international arbitration community need to up their game, right? And some of the reforms that have taken place include the introduction of expedited procedures, introduced by many arbitral institutions, SIAC and so on across the world. Secondly, there have been costs, sanctions against parties and lawyers for delay tactics. I've already given you one example of a fee sanction against arbitrators for delay, the ICC example. One other development which is likely to make arbitration, remain as an attractive element is hybrid forms of arbitration. With the advent of the Singapore Mediation Convention, MED-UP or UP-MED or UP-MED-UP has become very popular. And 50% of people currently surveyed prefer a hybrid form, arbitration with mediation, for instance, as opposed to just the classic arbitration. As a form of, to allow for a greater flexibility to terminate the dispute earlier rather than later. Now, I want to say in conclusion, really, at the moment, you still have a situation where, one, arbitration is still the most preferred method of dispute resolution. Two, dispute resolution before courts, such as the International Commercial Court in Singapore, London, are gaining popularity very quickly. But because of reforms that are being carried out, even in the international arbitration sphere, the sense is that arbitration will continue to remain an important avenue for dispute resolution of cross-border disputes across the globe. So it's likely to be, you're going to have a choice between international commercial courts and international arbitration, and some would prefer one over the other as time goes on. And of course, if state courts, increasingly more state courts across the world, institute reform and improve their processes, municipal or state court litigation may also become as popular as these two existing forms. With that, I want to say that I've come to the end of my presentation, and I'll be happy to take questions. Thank you.
Господин Ксавьер, во-первых, большое спасибо. И, наверное, мне бы прежде всего хотелось вас
Thank you
спросить.
very much, Mr. Xavier. First of all, I would like to ask you, as far as I understand from your address, is that you see the opportunities for developing the government forms and arbitrage forms. And in each of your reports, you provided for growth points. In this context, do you see any advantages on reviewing specific cases in specific types of courts, for instance, in government courts, international commercial courts, or arbitrage courts?
I'm afraid somebody will, that's a question somebody has to translate that to English for me.
Перевод не слышен? Еще раз. А сейчас вы... Да. Сейчас, одну секундочку. Так, а мне что сделать? Да, я сейчас вам скинула инструкцию по включению в Zoom.
I have now sent you the instructions for turning on interpretation in Zoom.
Find the translation button with the global icon on the bottom Zoom panel, please. Press the indication button.
I'm afraid I don't have that on my, because I'm in a virtual room and I don't have a computer screen in front of me. I could call my IT guy. Just give me a moment.
In your opinion, Mr. Xavier Francis, what is the difference of the cases between the please without translate. Xavier, what do you think about difference between state courts, arbitration, and international commercial state with the more popular case in state court in the arbitration?
Is the question whether domestic arbitration is more popular or as compared to state litigation? Is that the question?
What cases should be heard in arbitration and what cases should be heard in state courts?
Right. Now, I think there are a number of cases which are not suitable to be heard in arbitration. So you have criminal cases, which obviously need to be heard in a state court, right? If somebody has murdered someone or if somebody has committed a crime, criminal cases cannot be heard by way of arbitration. In many countries, family disputes, divorces, or division of family assets, when a husband and wife divorce, are also not matters that can be determined in an arbitration. It has to be heard in a state court. Now, that's changing in some countries. In some countries, like in the US, some aspects of divorce proceedings, like division of assets can be heard by way of an arbitration. But by and large across the world, family disputes, custody of children, for instance, cannot be heard in an arbitration case. But and sometimes also in many countries, insolvency disputes, whether you wind up a corporation or a company because it is insolvent, that again cannot be ordered by an arbitrator, but has to be by way of a state court. But except for these limited cases, all other commercial disputes can be heard in arbitration as in a state court.
Thank you so much. Thank you so much, and we will glad to see you again. Thank you, Mr. Уважаемые коллеги, я хотела вам сказать то, что должна была в начале, сказать в конце. Во-первых, я должна сказать, что конференция...
Since we have no audience, the simultaneous translation will be finalized now. It is suspended. Please raise your hand if you require translation into English. We are now suspending English translation. We're hearing the thanks to the organizing committee and the wrap-up going into wrap-up.
Валерьевич, студент 4-го курса Института правового консалтинга Университета Академии, его заместитель Мартынов Андрей Андреевич. По-моему, все просто ребята ушли по делам и занимаются продолжением обеспечения конференции. Калашьян Анжелика Альбертовна и Мухина Юлия, Степина Ангелина, Немагоева Ирина, Хайруллин Денис, Ивлева Полина и Пяк Виктория. Я думаю, что... И еще большой круг неназванных участников, волонтеров, которые свое силы, время тратили на то, чтобы организовать эту конференцию, за что им огромное спасибо. Я очень благодарю наших партнеров. Это прежде всего «Консультант Плюс», это наши коллеги адвокатов, выказавшие нам поддержку, Кожевников, Дарчиков, Зайцев и партнеры, которые оказывают услуги и бизнесу, и государственным компаниям, финансовым институтам, и иностранным предприятиям, и физическим лицам во всех юрисдикциях. Это наше сотрудничество выпускников, о котором уже, собственно говоря, мы упоминали, и председатель которого здесь выступал, они нас действительно очень поддержали в рамках подготовки этой конференции, точно так же, как и наш ректорат, который в настоящий момент уже отсутствует здесь. И еще я хотела сказать, благодаря нашим организаторам, то есть Петру и Андрею и другим ребятам, у нас сегодня будет культурная программа для участников, зарегистрированных участников конференции. Мы не сможем пригласить всех в театр сейчас, потому что работают ограничения, но с 3 часов по специальной ссылке будет доступна возможность посмотреть в записи оперу Россини «Итальянка в Париже». Запись будет доступна с 6 вечера до 12 вечера. Для коллег из Сингапура с 23, для коллег из Сантьяго с 12 дня. И в это время мы надеемся, что вы получите не только интеллектуальное удовольствие, но еще и культурное удовольствие, которое, собственно говоря, как правило, сопровождает все наши конференции. И я передаю заключительное слово Сергею Михайловичу Михайлову для того, чтобы сказать последние завершающие слова пленарного заседания, после чего объявлю о том, как будут проходить дальнейшие мероприятия по конференции.
Уважаемые коллеги, уважаемые студенты, я думаю, что первое, самое важное, целевая часть мероприятия состоялась. И были интересные доклады, был обмен мнениями, в той части, в какой это возможно, согласно нашему регламенту, и всем присутствующим, и очно, и онлайн. Я хочу пожелать успешной, продуктивной работы на секциях. И еще раз поблагодарить всех тех, чьими силами было создано сегодняшнее мероприятие. Спасибо большое. Всем успехов, удачи и здоровья. Спасибо.
Спасибо большое, Сергей Михайлович. Сергей Михайлович, большое спасибо. И теперь о дальнейшем расписании. В 14:30 у нас начинается панельная дискуссия «Качество инфраструктурных реформ правосудия». И здесь присутствует уже модератор Елена Георгиевна Авакян, советник адвокатского бюро Егоров, Пугинские партнеры и исполнительный директор содействия развитию корпоративного законодательства, также член Совета Федеральной палаты адвокатов. Елена Георгиевна, на секундочку включите свой микрофон, чтобы вас увидели все зрители. Отлично. Спасибо большое. В дискуссии будет принимать участие Кирилл Дмитриевич Титаев, Тимур Викторович Соколов, Михаил Зиновьевич Шварц и Айдар Рустемович Султанов. И если дальше у нас с вами и параллельно с этим, иногда чуть раньше, иногда чуть позже, начнутся секционные заседания для ученых и практикующих юристов. Секция заседания номер 1, специализация как тенденция развития цивилистического судопроизводства, будет проходить с 14:00. Модератор Дмитрий Александрович Туманов. Секция будет для участников в Zoom, и запись чуть позже выложена на телевизионном канале МГУА на YouTube. И в 14:00 начнется секционное заседание номер 2 «Конкуренция за спор, правосудие, арбитраж и альтернативные способы разрешения споров». Модератор Елена Ивановна Носарева, точно так же для участников в Zoom, но запись в последующем будет доступна. Параллельно с этим будут начинаться и будут вестись 3 круглых стола для молодых ученых. Первый стол начнется в 15:00. Арбитраж и альтернативные способы разрешения споров в России и в мире. Он будет происходить полностью на английском языке. И, соответственно, там будет Zoom-трансляция. Модератором этого круглого стола будет Дункан Спеллер, партнер практики судебных разбирательств и споров и член группы международных арбитражной практики из Лондона. Круглый стол номер 2 «Судебная юрисдикция по частно-правовым спорам» будет начинаться в 14:30. И этот круглый стол будет модерировать Андреева Татьяна Константиновна, всеми любимая, заместитель председателя Высшего арбитражного суда Российской Федерации в отставке, доцент кафедры гражданского процесса.
Now reading out the agenda for the following days of the conference.
Елена Сергеевна Смагина, популярнейший у всех студентов страны, я думаю, один из самых известных специалистов в области, в том числе не только гражданского процесса, но и по вопросам судейства студенческих мероприятий, заведующая кафедрой гражданского процессуального и трудового права Южного федерального университета, и Максим Дмитриевич Олегов, доцент кафедры гражданского и административного судопроизводства, один из наших уникальных специалистов и один из самых блестящих лекторов на нашей кафедре. Что касается третьего круглого стола, круглый стол номер 3, арбитраж и альтернативные способы разрешения споров, реформирования и внедрения, то его будут судить арбитры Фильченко Денис Геннадьевич, кандидат юридических наук, доцент кафедры гражданского права и процесса Воронежского государственного университета. Этот круглый стол начнется в 14:00, и Геннадьевич известен как один из самых популярных авторов именно по этой проблематике. Сорокина Анна Александровна, председатель Объединенной службы Skills Law Academy. И Будылин Сергей Львович, советник адвокатского бюро Бартолиус и партнеры. И помимо этого у нас с вами ждет еще одно большое, важное и значимое события. 13 числа, на следующий день, в 11 утра, состоится лекция судьи Конституционного суда в отставке Тамары Георгиевны Морщаковой, Института судебной власти «Проблемы и перспективы». На эту лекцию надо было подавать заявки, и выигравшие по вопросам будут участвовать в Zoom, все остальные могут посмотреть трансляцию по регистрации в YouTube. И я думаю, что в рамках проблемы сферы правосудия никто в стране так хорошо не сможет ответить на все вопросы, связанные и с конституционным правосудием, и с инфраструктурными вопросами институтами судебной власти, конечно, как Тамара Георгиевна. Большое спасибо за то, что Тамара Георгиевна согласилась выступать в рамках данной конференции. И, наконец, в 15:00 предполагается закрытие конференции, которая будет происходить с участием закрытие конференции, которое будет происходить с участием Кирилла Дмитриевича Титаева и моим участием на платформе Clubhouse. Вот, пожалуй, на этом и все. И я напоминаю еще раз, что у нас будет в 6 часов вечера сегодня культурная программа. Дорогие гости, у нас сейчас перерыв, и начинаем работать с 14 часов в зависимости от площадки. Всего доброго.